Hi, good morning, everyone. We had a few technical difficulties. For those of you who were hanging out for a few minutes, thank you. We're switching back from Teams to Zoom, and technology is wonderful when it works and slightly troubling when it doesn't, but we've got it now. So we're good to go. Hopefully, many of you will recognize me from prior seminars and webinars. I'm Ann Lavelle. I'm the CTR compliance specialist. Um, just so that everybody knows, because I know some of you are new here, we do these once a month, typically on the second Thursday of the month. And we usually do quarterly seminars for clients and friends who want to come. We're going to have one in April. The date is not quite set yet, but that's nice because they're in person and you can get questions answered in real time. So we're always looking for ideas for these webinars and seminars. If you have topics that you think might be of interest, please feel free to pass them along. These webinars are recorded. They are posted to our website. And anybody who has signed up for this will get an email with the content of today's webinar. So if you want to look something up or want to redo something or share it, you can. Please feel free to post any questions that you have in the Q&A or the chat. I try to check both during the seminar routinely, and we try to get everybody's questions answered that we can. In my prior life, I was a partner in a very large law firm. I did management side labor and employment law, and that is my background and my history, and we may have lost my image. I'm not sure. On my screen, my little video just cut out of my face, but that's okay. You don't need to see my face. Trust me, it's not worth it. We'll just move along. Overall, we're going to talk about DOL audits, okay? This is sort of the roadmap of where we're headed today. How does it start? Do you get an attorney? Do you do it yourself? Because attorneys can be expensive. What records do you turn over? How do you decide that? Because undoubtedly the DOL will request a lot of records. Do you have this on site, this investigation? And what if there is a mistake? What if you say, either at the start of the audit or the middle of it or the end, you say, oops, we've got a problem. How do we handle that? How do we handle the liability? So that's sort of the roadmap that we're going to take today. Well, how does it start? Really and truly, it should start with an ounce of prevention long before the DOL, that's the U.S. Department of Labor, or the Pennsylvania Department of Labor and Industry, or whatever state you may be in, shows up at your doorstep or sends you a letter. They don't usually show up at your doorstep. They send you a letter. But where you should be as an HR professional is saying, hey, I'm just going to do a little audit because, you have extra time, right? As an HR professional, I can add one more thing to your plate. We're going to do an audit once a year to kind of look at our payroll, at our positions, at our classifications, because the law is fluid and it changes over time. And we're going to make sure that we're compliant. And the hope is that we catch anything in its infancy before the DOL or somebody shows up at our doorstep. One to consider is having Labor and Employment Counsel involved in the audit. The beauty of that is you can keep the results, or at least some of it, privileged, which means it's not discoverable if somebody sues you. The downside of that, of course, is expense. When would I use counsel in an internal audit? Well, I would use them if I think I have a position with a problem and I have lots of folks in that position, because that statistically increases my likelihood of having an audit or being sued and having a problem. If I feel pretty good about things, maybe I just do this once a year just to make sure that I'm okay. We're not just looking at the accuracy of the payroll. We're looking at job descriptions. Does our job description make sense? The duties, tests, and classifications under the Fair Labor Standards Act. And if you have not, or if you have questions about the FLSA, we've done a number of webinars on classifications, duties, tests. What does the salary basis test mean? That's really not the topic for today, although I'm happy to answer questions. We do have those webinars recorded, so you can go back and look if you have questions about those concepts. Exempt versus non-exempt. One of the things in Pennsylvania that employers routinely get dinged for are payroll deductions. And I don't mean deductions for health and welfare plans. That's perfectly okay. You should be doing that if that's how your plan is set up. I'm talking about deductions for things like shortages or tools or whatever it might be. They broke something. Those are the types of deductions that, particularly in Pennsylvania, because you're dealing with both federal law and state law, are highly questionable as to whether or not you can do that. And we have, again, webinars on that as well. You're reviewing your policies. You want to make sure you have policies that are flexible, that if somebody works through their lunch hour, you can say, oh, we have a system. We don't just automatically ding them for a half hour, because if they work through their lunch hour or they got called away in the middle of the lunch hour, we have a system. We have a policy that says, hey, Joe, you need to go see HR and tell them you work through your lunch hour and we can override the automatic half-hour deduction or whatever it is. You need to know the differences between state and federal regulations. And so that's always complex, especially if you're in multiple states. So you have the FLSA, the Fair Labor Standards Act, which controls most of this. But then you have states like Pennsylvania, and again, we've covered this in a different webinar. Pennsylvania's wage and hour law does not completely mirror the FLSA. So if you're going straight off the FLSA, you will be running afoul of Pennsylvania wage and hour law. That would be true for other states like California, Colorado, different places that have different and unique aspects to their wage and hour law. Pennsylvania is unique in that it doesn't recognize the computer professional exemption. It doesn't recognize what we call the 8 and 80 exemption. Again, we've covered this in other webinars. But when you're self-auditing and saying, do I look good every year? Because I don't want the DOL on my doorstep. And if they show up, I want to look good. You want to be looking at things like that. Am I in compliance in every state where I have an employee? It's not every state where the employer is, particularly with remote workers. We're looking at every state where the employee is. So if you have employees in Ohio and Indiana and California, you should be complying with those laws, not just where your headquarters is. Your overtime calculations, that's another big area to audit. Oftentimes people have that messed up, particularly when you have variable rates of pay. We did a seminar or webinar on that as well. Rounding. So a lot of times folks round payroll because it's easier, and certain de minimis rounding is allowed, but sometimes employers take that a little too far. And most importantly, probably, or certainly at the top of the list right at the moment, mainly because the current administration, and I try to stay apolitical, but the current administration views workers as employees, not independent contractors. We talked about this in several webinars as well, but an independent contractor should look like the plumber who comes to my house, works for multiple people, has his own tools, has his own business. The only thing we agree on is the scope of work and what he's getting paid for that work, and probably the time he's showing up. I don't give him an employee handbook. I don't have him sign a non-compete saying he can't go to my neighbor's house. If you have independent contractors, and you have a lot of them, you probably have a problem. And if they don't meet what I call the plumber test, you are going to have a really significant issue at some point. So just keep that in mind. All right. Hopefully we've done our own internal audits, because that's really where it should start, is an ounce of prevention. But let's say despite that ounce of prevention, or even without that ounce of prevention, we get an outside audit, and it happens all the time. As a partner in a really large firm doing labor and employment management side law, this was pretty routine work for us. So what typically happens is these are almost always employee driven. And what I mean by that is some employee turns you in and files a complaint and says, hey, ABC company is doing this wrong. The employee may or may not know what they're talking about. You will not know for sure if an employee has filed a complaint against you or tipped off the DOL or the state, in Pennsylvania, it's called the DLI, to come investigate you. They will not tell you. There are random audits. That is possible too, but there's less of them. Those random audits where the DOL or the state equivalent agency decides to come look at something is usually in what I'll call low wage earner companies, hospitality, janitorial, some healthcare workers, temporary workers, because a lot of them, there's issues as to whether they're getting paid right, if they're coming from a different employer to you, you're the receiving employer. There's all sorts of issues. So most of the time, when you get a letter, and that's how these usually start, somebody doesn't show up at your doorstep usually, is it says, hey, we're the DOL. We are investigating you, and here's what we want. And we'll talk about what they want. And it's a very formal letter meant to make you give it due consideration and kind of worry you at the same time. And then a really common reaction from employers is to go on a witch hunt within their organization. Because the DOL is not going to tell you who or said what or what happened that they're, investigating you. But you may be able to tell from the letter, it looks like it's this issue. And I know, Ann LaBelle, she's always the troublemaker of the group. And I would believe she would turn us in. And I didn't like her anyway. So I'm going to fire her or make her life miserable. That's retaliation. That gets you in more trouble than the original complaint. So don't do that, even if you suspect you know who did it. The DOL really frowns on that. So the letter, what is in it? It comes from an investigator. They will make a request for certain documents, which you should have. We'll talk about whether or not you turn over all those documents. But the documents that they are asking for are things that every employer should have. Job descriptions, handbook policies about wage payment, the actual payroll records. Obviously, you should have those. Hours worked. And I cannot tell you, that sounds so simple, right? Hours worked. In about half of these cases, that becomes a huge issue as to whether the employer can produce accurate, and that's a key term there, accurate hours worked records. What often happens is the employee will say, hey, I worked 100 hours every week, 52 weeks a year. And the employer says, no, look, your time card or your online punch-in shows you only worked 30 hours a week and you only worked 40 weeks of the year. And then the employee says, well, remember when you called me in, or remember you did this or that, and we don't have a record for it. So it's very important that we have accurate records, and that in my ideal world, the employee has created the record, because if I, Ann LaBelle, enter my own time, I should be entering it correctly. And if I'm not, I'm lying to you as the employer, right? As opposed to the employer just automatically enters the time or does something like that. Not that you can't, but it opens you up to more of an argument that you have somehow played with the time records or done something squirrely with them. And that's obviously a no-no. Letter will ask for these documents in relatively short order, like a week or two. They don't give you much time to turn these documents around. And the main reason for that is the DOL is trying to prevent You reinventing the wheel, basically, to recreate or create in the first place records that you should be able to produce sort of at the click of a button. The expectation is that all these should be readily available and correct. You can obtain short extensions. So whether you're working with counsel or not, you should know you can obtain a short extension. And by short, I mean a week or two. So if they've already given you a week or two, you might be able to get another week or two. If you have really serious issues, you will never have enough time to recreate the wheel. You're going to have a problem. That leads us to the question of, what if you have a mistake at this point? Do you call in counsel whether you think you have a mistake or not? Well, a couple of things here. If you call in counsel at this point, which is what, when I worked as an active attorney, we always recommended that, because sometimes you don't know what you don't know. Attorneys, and I don't mean a general practitioner attorney, I mean a specialized labor and employment attorney, which is more expensive than a general practitioner attorney, have seen hundreds of these letters. They know who the investigators are. They know their style, whether they're difficult, shall we say, or not, the type of extension you might be able to get, and how the investigator will handle it if you actually have an issue. By the way, more globally, as you look at these types of letters, whether it's from the DOL or the Equal Employment Opportunity Commission or any other agency that you might get this from, it's often worth a call to an attorney who specializes in that area, because they can give you some background. If the letter is asking for X, Y, and Z, the attorney can say, hey, the probable issue that's been reported is ABC. What they're looking for is overtime, or what they're looking for is child labor, or what they're looking for is equal pay, or whatever it might be. So if you know you have a mistake at this point, right, you've got a problem, then certainly that pushes you more towards talking to an attorney, because you want to have an attorney, a labor and employment attorney, to cloak those conversations with the attorney-client privilege. So if you say, gosh, they're asking for all these records about our overtime calculations, and as I, the HR person, looked into it, or as I, the CFO, or whoever it is who wears probably a ton of hats and doesn't have time to chase after every nuance of the regulations, I looked into it and I think we might have an issue. That's the point at which you get counsel and you start talking with them to protect these conversations from being discoverable to the DOL, and say, gosh, I think I have an issue. Am I correct that I have an issue, or am I worrying for nothing? What's the scope or magnitude of that issue in terms of dollars and cents and potential penalties? And if it is an issue, how do I approach the investigator? Will you approach the investigator on my behalf? Decisions that you can make depending on the facts of where you're at and what you think your exposure is. Obviously, counsel is expensive, so you have to weigh the expense versus what you think your potential liability is. Who responds? Well, somebody needs to call up that investigator and say, hey, I'm your point of contact. Whether that is an internal person, whether that's the HR person, senior management, the owner of a small company, whatever it is, they need to call up and be, hey, investigator so-and-so, I got your letter. I'm on it. I'm the point of contact. Here's my name, number, whatever, so that that investigator knows who to reach out to. It's the right time to ask for an extension too, if you think you're going to need an extension. One thing to point out here, in Pennsylvania, and this is not true in all states, but in Pennsylvania, senior management and the owners, like the board of directors, the owner, can be personally liable for wages, even if the company is incorporated. And that is very different than what most people expect, right? So if you're just a supervisor, you're not responsible for unpaid wages. But in Pennsylvania, if you're an owner, a board of directors, somebody who's extremely high in management, you can be personally liable for unpaid or mispaid wages. So as you weigh your response to this, and if you're the HR person who's been charged with responding to this and you think you have an issue, it's worth making senior folks in your company aware of their own personal liability if they're in Pennsylvania about this type of issue. That may, they may initially balk at getting counsel because of the expense until they find out that they can be personally liable. So something to think about. If you know you have an issue, you should think about voluntary compliance. There's something to be said for saying, because the DOL is used to employers messing up. That's their bread and butter. Employers mess up. We recognized when we got your letter that we had an issue. Here's what we've already done to fix it. We're going to do this, that, and the next thing in the future. And maybe we're paying back wages that we messed up on. That might be cheaper than counsel, especially if it's a limited group of your employees that has this issue. We may look at voluntary compliance and say, that's what we're going to do. Or we may say, no, you know what, this is a gray area of the law. And we think these people are exempt. That's usually where the gray area comes in. We don't think they're owed overtime, and we're willing to stand by that decision. No matter what the DOL thinks, we're willing to take that fight on. Criminal issues. This is unfortunate, but I can't tell you the number of times this would come up when we were defending a DOL investigation. Somebody at some point would say, we have something we need to tell you. And then they would make sure there was the attorney-client privilege, and we'd say yes. And they would then go into the story of how they were paying some of their employees under the table. We had that in everything from the mom and pop pizza shop to a huge company was doing it, because the huge company was founded by a family, and the original workers, they had paid under the table, so they just kept doing that even though their company grew to several hundred employees. There's lots of issues, right? That's a criminal issue, it's a tax issue, it's a reputation destroying issue. It's just terrible. Whenever we got that type of scenario, we called in criminal defense attorneys because we didn't do that type of law. And the DOL shares information with the IRS and the EEOC. They have like an arrangement, a written arrangement that says they will share this type of information, not just on criminal issues, but like if the DOL stumbles into a discrimination issue, they very helpfully inform the EEOC or whatever, or vice versa. So whatever you do, and the other way that paying under the table would come to light is one of the employees would tell somebody, either because they were afraid they were about to be liable themselves criminally or for tax stuff, or because they were one of the employees not getting paid under the table and they were jealous. So the employees were often the ones who threw the owners or whoever were paying under the table under the bus. All right, and again, the sharing of information when these issues come out, the DOL, the EEOC, the IRS, the National Labor Relations Board, whoever you want to pick as a federal or state agency, they're very helpful with each other, and they share information. So if it's something that doesn't fall under their umbrella of enforcement, they share it with the agency who does enforce it. All right. So once you contact the auditor or the investigator and you introduce the employer contact, remember that honey gets you further than vinegar. Do not get irate at the investigator that you've received this letter. Don't demand to know who is the impetus for this letter. That's just going to cause problems for you later. Be civil. If it's not clear from the letter, and sometimes it's not, try to find out what the main issue is. What are they looking for? What do they think the problem is? Is it, the common ones are exempt versus non-exempt under the FLSA, mispayment of overtime or not calculating it correctly, independent contractor versus employees, or child labor. So this is a big one, particularly at the state investigative level. So for anybody who's looked at the Fair Labor Standards Act, there's child labor law in there. Pennsylvania is stricter, as are many states, on child labor law. So just because you comply with the FLSA for child labor purposes does not mean you're going to be in compliance with Pennsylvania law. And so you often get the Pennsylvania DLI stepping in and saying, hey, do you contact the school districts when they quit? Do you do this? Do you do that? And if you have no idea what they're talking about, it's probably because you've complied with the federal law and not the state law. You want to watch open, and assuming you're responding on your own and you decided not to opt for counsel, either because of cost or because you think your house is in pretty good order, or you think the liability that you have is less than the cost of counsel, which could be true, you want to watch the requests. Sometimes these requests don't set appropriate parameters. So when you talk to the investigator, you want to set some parameters. There's no such thing as an open-ended request. We want all your overtime records. Well, no, we are not going to do that because the statute of limitations for these claims is between 2 and 3 years, and I'll explain that in a second. So I'm not going to turn over records from 5 years ago or 10 years ago or 15 years ago because they cannot possibly be relevant in most cases. So you're going to say, hey, I want some parameters here. Or if they say, I want every job description under the sun, and you're a really large company with 10,000 employees, that may be a ridiculous request. Or even if you're a smaller company with 100 employees, you may say, well, what job category are you really looking at? You probably don't want the job description for the president of the company, right? He or she is probably not the one who turned us in here. Is there a particular classification of worker that you're looking at? What do you really want? We're going to send you the relevant records within a certain time frame. And that time frame, let's talk about that. So it confuses a lot of employers as to a statute of limitations means that's as far back as the agency can go to assess back wages, penalties, interest, attorney's fees, etc. Under the FLSA, it can get a little confusing as to what the statute of limitations is because it's either 2 or 3 years. Why is it either 2 or 3 years? Why not just a set number? Well, the 2-year statute of limitations is if you basically, as an employer, have done everything right and you have what I'll call an innocent mistake where you didn't have an opportunity or couldn't possibly have known better to not make the mistake. As opposed to a 3-year mistake is more like an intentional mistake that you should have known better. Okay, and a lot of employers were like, well, if I'd known better, I wouldn't have made the mistake. So I'm the 2-year statute of limitations. Unfortunately, most investigative agencies say that the longer statute of limitations is appropriate in most cases because in most cases, you either knew or should have known about the law and what it required. Even if you're the small mom and pop pizza place or whatever, you should have known what the law required. And therefore, the records we're going after and the scope of liability is 3 years, not 2 years. All right, what records are you going to provide? Let's talk about this a little bit, and I'm going to give out a dirty little secret about attorneys too here. Whatever records you turn over, whether you're turning them over to counsel first, who's then going to provide them to the DOL or the state agency, or whether you're directly handing over the records to the DOL or the state agency, you're not going to hand over originals. I guarantee you the best way to lose your records is to hand over originals to either your own attorney, that's the dirty little secret there, or the DOL. Either one. It's like Murphy's Law. They will lose originals. So the first thing is you're going to make copies. And then, especially with counsel, you may make copies of, let's say, 500 documents. We may not end up turning all those over. right? Or you may initially, if you're responding to the DOL, say, hey, maybe these 200 documents are relevant. Make copies of them, and then you only turn over maybe 150 as you look over it. You want to know which documents you turned over, because these investigations can last months and sometimes years. And you want to know what you have turned over, and guaranteed your memory will fade. So what attorneys do, and what you should consider if you're thinking about handling this yourself and turning over your own records, we do something called base labeling. And what that essentially means is I'm going to number each page that I turn over. I'm not numbering the originals. I've made my copy of the 100 documents, and I'm going to label them essentially 1 through 100. That helps in certain ways. One, you can identify the records you have turned over, because oftentimes what happens too is you turn over the first 100 records, and then the DOL says, well, gee, thanks, but we'd like these records too, because after we reviewed the first 100 records, it raised additional questions, and now we want X, Y, and Z also. And so when you turn over the second set of records, you're going to label those perhaps production number 2, 1 through whatever, or you start at 101, however you're numbering them. The way that helps too is then if the investigator has a specific question and says, I want to talk about Ann Lavelle's payroll record, they can look at the number at the bottom of that document, say, it is document number 27. And everybody knows the record they're looking at. And it's Ann Lavelle's payroll card from February 8th, 2024. I had to think about what year I was in there for a second. Gosh, she did this wonderful, wonderful webinar that day, and we're looking to see whether or not she got paid for it or not. And she says she has, several witnesses that she did this too. So in any event, that's the type of thing. It helps to have the discussions with the investigators if you have numbered your records. It helps you in terms of your memory to know what you have already produced and in which production cycle you have produced it. Was it in response to the first letter? Was it in response to a second or third request? And some of you might be sitting out there saying, well, forget the DOL, or maybe you're using stronger language than that I can't use during the webinar. And you say, I'm not turning diddly squat over to them. They can sue me. Well, guess what happens? They have subpoena power. They can sue you. That is probably not the path you want to go down. Thumbing your nose at one of these agencies and saying, come get me, usually means they will come get you. So it's better to cooperate. If you have some really big concerns, like criminal concerns, you involve counsel, obviously, or if you think you have huge liability, you involve counsel. But even counsel will tell you, you don't just ignore the DOL or refuse to turn stuff over, because they can subpoena it, they can go to court, they can do all sorts of stuff. Right. So those are some mechanics, if I can put it that way, of making the investigation go in an orderly fashion. Most of the time, the DOL wants to come talk to your employees. What do you do about that? Right? You can't force any of your employees to either talk to the DOL or not talk to them. That would be interference if you told Ann Lavelle, whatever you do, don't talk to the DOL. No, rather, we can help facilitate this, right? They'll usually want to come on site and talk to them. We arrange it in a quiet area within the workplace. That's a non-customer area. That's private and secure. We're not listening in. They have an office with a door or something so that the employee does not feel threatened. You are not going to be able to sit in and listen to what's going on. There's no retaliation. So it doesn't matter if the DOL talks to 2 of your employees or 100 of your employees. It doesn't matter who they call in. These people may or may not have had anything to do with this investigation. They may just be in the same job classification or same job category as what the DOL happens to be looking at. It may be a clue as to who turned you in and who filed the complaint, but you can't take action, right? If you retaliate, you're putting yourself in a horrible position, because that person who is retaliated against can claim not only whatever back wages you might owe them if you messed up under the FLSA or the state wage law, but they can get additional damages if you've retaliated against them, if you've disciplined or fired or whatever the retaliation might be. You change them to the midnight shift. Just don't do it. All right. What happens after the investigation? So you've gone through months of this rigmarole, right? You've produced documents, maybe a couple times you've produced documents. You may have had interviews of different employees, and you, the HR person, may have been interviewed, or the owner, or whoever's responding here. If you are the owner or management, you generally can have counsel with you, and you probably want to do that if they're talking to you, but again, that's your call. You will receive some type of summary with respect to the investigation. More often than not, there's a list of violations because it is extremely difficult for employers to comply with every aspect of the FLSA and every aspect of every state wage and hour law and every aspect of every local wage and hour law. I mean, you could drive yourself crazy doing this. Obviously, we should be making a good faith effort, but they're likely to find something. What do you do at that point? The first thing I would urge you to do, especially if you've handled the investigation yourself, and I'm no longer a practicing attorney, so I have like no dog in this fight, but what I would tell you to do is reconsider the option of counsel. Yes, the attorney is going to say, oh, I wish you had talked to me sooner, but they know what can be negotiated. And oftentimes, the list of violations is based on legal theories. So let me give you an example. You may say, gosh, Joe is a first-level supervisor, and he's exempt. We don't pay him overtime. And here's why he's exempt. He's under the executive exemption. He meets the duties test. We pay him the salary basis. Most of his work is managing 2 or more employees or whatever. And the DOL says, no, he's a first-level supervisor. He's doing the same work as the people under him. That's really a legal argument that has some factual overtones to it. Counsel can pull up case law and say, hey, you know what? Here's an analogous case. And in that situation, Joe, the supervisor, was exempt. Or maybe they pull up case law and tell you, you know what? You're up the creek without a paddle type of thing. There's no way this first-level supervisor was exempt. You made a mistake, and now we have to fix this. But oftentimes, the arguments, whether it's independent contractor versus employee or misclassifications, are legal arguments. And if you're not well-versed in what the law requires, and really, how can you be? Because you're running a business. That's your first and foremost important thing to do. You may not appreciate all the nuances, and you don't want to roll over and just pay everything if you don't have to. But on the other hand, if you're up that creek without the paddle, you want to know that too, so that you can try to resolve it in the most cost-effective way possible. Again, you want competent labor and employment counsel. You do not want a general practitioner helping you on this because this is a very nuanced area of the law. You can negotiate these resolutions, right? And counsel will know if the DOL is saying you owe, $50,000 in back wages and penalties and interest and this and that and the next thing. Counsel's going to know how much of that might be negotiable. Can we negotiate the penalties down, even if we owe the back wages? You also want to be very, very careful if you're handling this, that if you're paying out money, you don't want your employees, right? That you're paying this to the DOL who's going to distribute it to your workers in some fashion. You don't want to pay it to the DOL only to turn around and have your own employees say, wow, that worked pretty well. I think I will sue ABC Corporation for something else, right? Or, hey, look what the marketing department got. I'm in the production department. I think I will now file something. You want to watch those types of issues, and you want to get appropriate resolution documentation in place so that you're not in a position where you've paid the DOL to pay Ann Lavelle $5,000 to resolve the claims, and then Ann Lavelle comes up with the next set of claims. or says, I want more or whatever. So you need, and often counsel can help you with this, is appropriate settlement or resolution documentation that says, hey, this is it. If we have paid this because we messed up, settling the claims. This is not just the start of the claims. And the DOL can be kind of resistant to that type of documentation, but you want to try to be in a position to say, if I'm paying for something, I want this to be the end of it, not the start of it. All right, something that I want to touch on, because when people hear DOL audits, they think FLSA, right? Everybody thinks wage and hour, wage claims, exempt, non-exempt, employee, independent contractor. The DOL has a broader umbrella than that. So they also do what are called plan audits. What are plan audits and why should you care? They are health and welfare, meaning your health plan or other similar plans like the FSA, the flexible spending account, the health savings account, anything along those lines, or retirement plans, right? If you have a 401k, a 403b, whatever alphabet soup you have for your retirement plans, the DOL has the power and is charged with investigating the maintenance, the documentation, and the application of those plans to your workers. And they have some hot buttons. One is plan documentation. And until recently, and by recently, I mean probably 5 years ago, this was not a huge item for employers. They kind of just ignored it because the DOL was not really out there enforcing this as much as they are now. Health plans in general, retirement plans have come to the forefront. The DOL is much more active in looking at this, and they're looking for one, do you have the right documentation? Do you have, and this is not an employee benefits course here, but do you have a plan document? Do you have a summary plan description? Are you passing them out and getting signatures on a routine basis for these? If you're getting electronic signatures, do you meet the relatively tough DOL test to do that as opposed to a paper signature? Yes, that might be back in the dark ages, but that's what the DOL is looking at. Do you administer these plans appropriately, particularly if you are self-funded, meaning self-insured? And by the way, almost all flexible spending accounts are considered self-funded or self-insured plans. Do you have what's called non-discrimination testing going? And that does not mean we're discriminating against Anne because she's female or because she's pink with purple polka dots or anything like that. Non-discrimination testing means for a self-funded plan that we treat our executives and our lowest paid worker equally under the plan. They're worried about top heavy or top hat plans where the executive has zero copays and zero co-insurance and much richer benefits than the guy who's sweeping the floors or the gal who's sweeping the floors. Not all plans require non-discrimination testing. Most insured plans do not require it currently, although there is a move for that, but most self-funded plans do require it. More and more people have gone to self-funded plans because of the cost of health insurance, but be aware that this requirement is out there. If you have plans that look like it favors your high wage earners, you probably have a problem, whether that's your retirement plan or your health plan. The DOL does have various self-compliance tools online to help you figure out if you have a problem. Certain fiduciary violations, and most people on this webinar today who are in the HR department or CFO or whatever are going to be a fiduciary. This doesn't directly apply to you personally, but fiduciary violations have a mandatory 20% penalty. Failure to have certain plan documents is a per day penalty of a couple $100s. I mean, you can rack up these penalties in a ridiculously large amount very quickly. And again, this is not an employee benefits course where we're going over what all we need. I just want to make you aware. This is sort of like issue spotting. I want to make you aware that the DOL also covers these issues. They also cover FMLA audits, and those are somewhat common because employers, the FMLA can be a little confusing to administer, as are many laws, especially when you have, last month we did the city of Pittsburgh and Allegheny County leave laws. You get lots of overlap between different leave laws, and the FMLA can be even more confusing. But the DOL investigates that. They are looking for policies, application of policies, and consistency. That you're not, for some reason, treating Ann Lavelle better than Joe for some odd reason, or whatever it might be. FMLA is a little different too in terms of liability. So in FMLA, anybody who interferes with FMLA rights can be personally liable. And I have seen HR directors sued personally for this. So be very careful with that. Know what the law requires. Talk to counsel if you don't. But you need to be cautious of the FMLA and how you handle it, because it also is subject to a DOL audit. All right. Again, when we're just looking at the wage and hour issues, 2 to 3 years of statute of limitations. Pennsylvania, which is a little odd, does have individual liability. Just to recap that, for the owner or the board, some really high level, maybe the president type of person at the organization. What do you end up paying? Well, back wages. If you didn't pay the wages in the first place, you now have back wages to pay. And because the person didn't get them when they should have, there's interest, right? If you owed this to me a year ago and I never got it, it makes sense that there would be interest. There's also penalties, and the penalties are all over the place as to what they might be. But let me give you an example. Child labor law, for instance. Those violations are taken very seriously. You can get a penalty of $10,000 per child labor law violation, right? And remember, kids can start working at age 14 here in Pennsylvania. Younger if it's a farmer hiring them, or it's drama or acting or theater. Approximately, and we're going to use a little rounding here, $2,000 for minimum wage and overtime violations, typically calculated per employee. So again, starting with the very first slide, the best course here is an ounce of prevention is worth a pound of cure, is to look at and say, I've done a self-audit. I know how good or how bad I am. And if you say, gosh, my house is a disaster, and I know that, the sooner you get it in order, that statute of limitations is running, right? And so liability is falling off if you correct it now, right? And your hope is all that liability maybe falls off, or maybe you voluntarily comply and pay some of that liability just to get rid of it. But get the house in order, and then you don't have to worry about this whole situation as much. And if you get audited, you can feel good about things that you can survive the audit. All right, if there's any questions or any comments, please let me know. Otherwise, I thank everybody for attending. And if you have any ideas for future seminars, please let me know. And we're happy to look at issues that other people have. Again, we'll have another webinar next month, and then hopefully a seminar in April, and we'll go from there. Again, I thank everybody for attending. I'll hang on for a second just in case there's questions. And enjoy the beautiful weather. All right, it doesn't look like there's questions. Thanks everybody for coming. Take care. Okay, I lied. There's one question, so I'm going to answer that. If you discover an issue with an exempt employee that should not have been and want to pay them, how do you go back and calculate? So that's a great question. So this means we have somebody who was misclassified. They should have been non-exempt. So the first question I would have is, do we have any time records for them? If we don't, if we do, that makes this easier, right? We can look at those time records and say, okay, we can get a rough idea of what they work. But oftentimes exempt people don't keep time records. If they don't, we really have a difficult time knowing what to pay them. And we can certainly change them to non-exempt. That may be a red flag to them that they ought to be looking for back pay. We may be able, depending on how friendly or not they are to us, we can have a discussion with them of saying, hey, we're going to change this. Here's where we're at. The most common thing we used to do is oftentimes the person who's misclassified, it's a close call. So we don't go back and pay them, but we change their classification going forward. We hope that the statute of limitations starts dropping off the liability because we've now changed it. And if somebody starts rattling their cage, particularly if there's multiple employees in this category, we deal with it at that point to see if we should or shouldn't pay liability. But most of the time we take the position that it's a close call. We thought we were right. We still think we're right, but in an abundance of caution, we're now making them non-exempt. Okay, so somebody else asked, can the HR manager be personally held liable or personally held responsible, or is this only if heading up the audit? So let's break down that question. That's a great question. You are personally liable, you're never, assuming you're not the owner, assuming you're not like the president or on the board, even if you're the contact person for the DOL, which you could be as the HR manager, you're not personally liable for the wages as the HR manager. So assuming you're not the owner or the president or the board in Pennsylvania, the wage issue falls away. Here's where I've seen HR managers be personally sued in the FMLA situation, because the FMLA allows for a personal lawsuit if you have interfered or retaliated against the employee. So in that situation, both the employer and the HR person who's alleged to have interfered or retaliated can be sued. And that becomes a very difficult case because you have two defendants there, right? An individual who probably doesn't have the resources that the company has to retain counsel, et cetera. And you got the employer. And then you look to see whether or not what's called employment practices liability insurance would cover the HR manager who's been alleged to have interfered or retaliated. And I want to be respectful of everybody's time. I see there's another question here too, and I'll get to that. Let me give you a quick example of a case where that occurred. It was a nursing home. The HR director denied FMLA leave to a lady who had multiple sclerosis. I am not sure why they ever denied leave. I don't know what they were thinking, but they did. That's interference with FMLA. And like of all the denials of FMLA, I don't know why they went for that one. But anyway, both the nursing home and the HR director were sued, the lady who made the decision. And there was liability there because it's pretty clear that multiple sclerosis is a serious medical condition. In that case, we worked on just resolving it. And the nursing home agreed to pay for the HR director's legal fees. But it becomes an issue. All right, so you're not liable for the wage and hour, assuming you're not the owner, president, or board. But the FMLA is where you've got to watch yourself a little bit. All right, is there a resource or webinar available to review what documents are required for a plan audit? So great question, and maybe we need to do a webinar on that. We could possibly do that if there's interest. The first place that I would point you to is the DOL does actually have some great resources on what's required, but basically what you're looking for, whether it's a health plan or a retirement plan, you're looking for what's called a plan document and a summary plan description. That's some of the main documents you're looking for. If you are fully insured, the member booklet is not your plan document. A lot of people get confused about that. But your insurer may be able to provide you with a template for these documents that you can sort of plug and play, meaning those are usually set up so that you have to like insert your name and number type of stuff. You don't want to just leave it with employer and brackets on the document. But those are the two places and the least expensive places that I would start looking at in terms of resources. So I hope that helps. And if other people want to see webinars on employee benefits, let me know that too. Any topic, happy to try to cover. Okay, I hope that answered everybody's questions. Again, enjoy the nice weather and take care.